Hey there, this is Dale Carson again, live on Facebook. Want to talk to you briefly about what happens. You're out, you get arrested, you're in the back of the squad car. You're going to go downtown. You're going to be processed through booking. You're going to do a whole host of things which will seem odd to you. In fact, you go in front of Homeland Security and Immigration when you're brought into the Duval County Jail here in Jacksonville, Florida. After that, you go in front of a judge. Now, the way the rules work, you're going to go in front of that judge within an 8-hour period. And after you appear, the critical point here is you're going to appear in front of the judge for some minor offense. Let's just say you were trespassing on somebody's property, or you're arrested for shoplifting. Whatever those things are, the judge may offer you the ability to just plead out right at first, what we call first appearance, the first judicial official you see, and give you time served so you can go home. You don't have to pay a bond. You just go home. You think it's all over with, but there's a conviction that generally arrives with that plea. So you'll be convicted of trespass or whatever it is. But Chris is here to tell you we have recently had a spate of, I guess it's spate of people wanting to withdraw pleas. And that means they've gone home, and their big brother says, "What do you mean you got convicted? How did that happen? I mean, you haven't really been in front of a judge." "Oh, yes, I have. I went for first appearance, and the judge offered me this deal, and I took it." That may be a mistake.
And so one of the issues that we run into a lot when someone goes through first appearance, and this is pretty much universal, but we deal with a lot of them here in Duval and the surrounding counties. When someone is taken into first appearance, a lot of times they are in a less than good frame of mind. They have spent the night in jail, quite possibly they've never been through anything like that before. They are thrust in front of a judge in shackles and uncomfortable clothes, and they're really just in a situation that's not a good one.
And they're benchmates. You might mention them as well. They're benchmates. The people they're sitting next to, right?
Yeah, well, and exactly.
Are really hardened criminals, or you think they are.
Correct, and they're thrown in with people who who you wouldn't necessarily want to go have a beer with. And so as a result of that, the overall kind of feeling in first appearance, as far as people's gut reaction goes, is, hey, this is terrifying, get me out of here. And one of the ways that comes through oftentimes is when the judge or the prosecutor may make an offer to a defendant, at which point they may just say, hey, it's in my interest to do this. They're telling me if I take this, I'm going to get out of here now. And lo and behold, that is not always the best decision. For the most part, it is made without the ability to consult with an attorney or really give any deliberate thoughts to some of the consequences that may come from that. And as a result, many times people regret doing what they did at first appearance. And we represent a number of folks, and have done so for years, who have actually gone through the first appearance process, and then after being able to either think about it for a few days or to see some of the consequences that have come from the decision, because many times criminal charges can have collateral consequences that are not always explained to someone when they enter a plea.
What are those, Chris?
And things like driver's license suspensions, inability to own or possess certain firearms, loss of concealed weapons permits.
What about school?
Sure, there can be issues with schooling, there can be issues with student loans, there can be issues with jobs. I mean, there's a litany of different issues that can arise from that. And as a result, once the defendants have had time to think about it, they may say, wait a minute, that wasn't a good idea, I want to fix it. So the real question then becomes, can it be fixed? And in certain circumstances, it absolutely can. One of the requirements on something, which is what we consider a motion to withdraw a plea, would be, number one, the timetable. If someone enters a plea, then there's a fairly narrow window that they would have in order to withdraw that plea.
So when you say enter a plea, what happens? What's the colloquy? What happens when you enter a plea? Does a judge ask you something or talk to you?
Well, they don't always ask, although they're supposed to. But the judge is required by law to conduct what's called a plea colloquy, which means that they ask you various questions to ensure that the plea that you are entering is free, willing, knowing, voluntary.
I got you.
And that it is actually what you want to do.
And a plea means that you're going to say I'm guilty or not guilty, right?
Well, guilty, not guilty, no contest.
Right, okay.
Oftentimes at first appearance, it's actually a no contest plea, but effectively that's the same as a guilty plea when push comes to shove. So when that colloquy occurs, the judge is tasked with actually ensuring that the defendant knows what they're bargaining for and what they're getting. And if they fail to do that, if there are certain things that the judge does not say or do, if there's certain information not provided to a defendant, that can actually provide grounds for a motion to withdraw a plea. And so when it comes time to look at something like that, the biggest issue with a motion to withdraw a plea is a timetable. Usually you're looking at 30 days. There are some ways we can work outside of that 30-day window, but it's tough. So if you have been put into that position where you have entered a plea and are feeling some sort of regret as a result of that, the biggest key is make sure you speak with a lawyer such as us within 30 days, because once you get outside that window, it becomes much more difficult. Once we actually start working through a case, and I actually have a number of them going right now, we pull a transcript of what was said by the judge, what was said by a defendant, what was said by any of the attorneys, anything else, and we review that to see if there are sufficient grounds in order to withdraw it, at which point we can make some decisions on whether or not to go forward. But I think the biggest takeaway from all this is the timetable is extremely important on a motion to withdraw a plea. If we don't get it within that narrow 30-day timetable, it becomes much more difficult to do.
And when you withdraw the plea, is it like starting over? Is it like starting over? I mean, what happens when you withdraw the plea?
If a plea is successfully withdrawn, it effectively kicks the case back to square one. So it will be the equivalent of just having pled not guilty at first appearance. You then are either ROR'd, post a bond, whatever it is, and then progress through with the case. You then get access to discovery. You can have your attorney review that and help you make decisions as far as the best course of action, with the benefit of all of the knowledge that we bring as attorneys.
Right. And how much do we charge for that service of actually chatting with an individual over the phone or over the internet to determine whether or not they have an opportunity to withdraw a plea?
Sure. Well, a basic consultation costs nothing.
There you go. That's what I was.
We're always happy to talk to folks about that. So that's not an issue. We field a lot of calls on that front. Even if you're not sure, it sometimes makes sense to at least talk to us just to kind of get an idea of whether it's something you would be interested in doing.
So if you have questions about withdrawing a plea and trying to start a case over that you recognize your first decision was not probably the right one, and we have this happen all the time, because look, when you're in custody and you're in jail, the first thought for all of us is, I want to get out. And getting out involves either a bondsman, if you have a bond, which is going to cost you money, or it's taking that plea, getting time served, and getting kicked to the curb, but it's with all that excess baggage that you're not possibly aware of at the time you accept that deal from the government, meaning the judiciary, the judge, and the prosecutor. So look, if you have questions concerning this or other matters related to the law, please don't hesitate to contact us at www.dalecarsonlaw.com, or you can call us on the phone, 904-355-6777.